Today we're going to discuss whether a federal judge can give you a lower sentence or depart from the federal sentencing guidelines if you make an argument that you didn't know or have any control over the purity or the amount of drugs involved in your case. For example, if you're a middleman between the supplier and the purchaser. This is so-called Mendoza departure. And if your lawyer is not familiar with this departure, it is perhaps time to hire somebody new. In this video, we're also going to discuss generally what the court must consider before imposing a sentence in terms of departures and variances. So if you're heading into a sentencing hearing in federal court, this video is for you. If you're new to the Law Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Mendoza, a Ninth Circuit case from 1997. I will tell you a lot has changed in terms of how we look at sentencing in federal court since that time, but this particular departure is still applicable and it is important for you to know about it. So let me give you a little bit of factual background. Mr. Mendoza, along with his co-defendant, met a confidential informant. There was an agreement for Mr. Mendoza to sell some drugs to this informant. They met together, and in Mr. Mendoza's vehicle, in his car, was about 804 grams of methamphetamine. At some point, Mr. Mendoza left the scene and met with Miranda brothers. In their van was about 2,500 grams of methamphetamine. Now, the idea was for him to get some of those narcotics and then sell them to the informant. Now, in this case, everybody gets arrested, and Mr. Mendoza is charged with distribution of narcotics, specifically methamphetamine. He's charged in federal court. He pleads guilty and is eventually waiting for sentencing. Prior to sentencing, the parties submit their filings as well as the probation department, and they calculate the federal sentencing guidelines. Now, in any federal case, the court must look at the federal sentencing guidelines prior to imposing a sentence. But remember, these guidelines are not mandatory. They're only advisory, meaning that the judge can give you a higher or a lower sentence than what the guidelines say. Now, in these guidelines, at the very end of the manual, there's a table. The table has 6 criminal history categories on top and 43 offense levels on the left. The intersection of those two have months in the middle. Those are the months of prison time that the court has to consider before imposing a sentence. Now, again, the court doesn't have to follow those, and when the court doesn't, they have to justify it with a departure or a variance, basically explain why they're going with a higher or a lower sentence than what the guidelines call for. When we're dealing with drug cases, we have to look at Chapter 2D 1.1. And just like any other cases, in terms of drug cases, it is this particular chapter, but it works the same way for any other case. The first thing we look at is the base offense level, which is basically the starting point in terms of calculating the guidelines. In drug cases, it is the amount of drugs that drive the guidelines. So in Table C, under the same chapter, you will see a bunch of drugs and the corresponding amounts in terms of the weight amounts of those drugs. And then from there, you will see the base offense level. When we're dealing with methamphetamine, you will see the difference between actual methamphetamine and a mixture. Now, we're talking about Mr. Mendoza's case. The probation department, as well as the parties, add the amount inside the vehicle that Mr. Mendoza owned, the 804 grams of methamphetamine, and roughly the 2,500 grams of methamphetamine from Mr. Miranda's van. That is because when we're dealing with conspiracies to distribute narcotics, a defendant can be liable for all the amount of drugs involved, including the amount that usually goes to his co-defendant. So here we're adding both of the amounts, but Mr. Mendoza argues that in terms of weight, he shouldn't be responsible for the pure methamphetamine. As a middleman between the supplier and the informant, he did not know or have any control over the purity of the narcotics. Now, in the district court level, the judge said that this departure is not appropriate. Essentially, Mr. Mendoza was saying, I would like to have a lower sentence because I didn't know the purity, and the purity makes a difference in terms of base offense level. Specifically in this case, it was 4-level departure. The district court judge said it was not appropriate for him to depart based on this argument because he said the guidelines already account for it. When we're looking at the base offense level, we simply have to look at the purity of narcotics and the weight, and that's it. Of course, this case goes to the Ninth Circuit, and the Ninth Circuit explains this to us. The Sentencing Reform Act of 1984 provides that a departure from the guidelines is appropriate when there exists an aggravating or mitigating circumstances of a kind or to a degree not adequately taken into consideration by the Sentencing Commission in formulating the guidelines. This is section 18 U.S.C. 3553B. Based on the reading of this section, the district court concluded that they could not depart or give a lower sentence based on the knowledge or control over the purity of narcotics. They said because the Sentencing Commission accounted for the purity of narcotics when formulating the base offense level in the drug guidelines. But the Ninth Circuit says that is not how we should be reading the sentencing guidelines. The Sentencing Commission expressly and categorically prohibited just a few factors that the courts should never consider at sentencings. Those include race, sex, national origin, creed, religion, socioeconomic status of the defendant. That's found in section 5H 1.10. Then the lack of guidance as youth, found in section 5H 1.12. Drug or alcohol dependence, found in section 5H 1.4, and economic hardship, found in section 5K 2.12. If the Commission has not categorically prescribed the factor, departure is authorized if the factor, as occurring in the particular circumstances, takes the case outside the heartland of the applicable guideline. The Ninth Circuit says that the departure based on the knowledge or control over the purity of narcotics is not expressly or categorically prohibited, and thus the district court can in fact consider it as a factor. The Ninth Circuit then says that in most cases, the amount or purity of drugs that are involved in the case will be attributed to the defendant, and he will in fact be responsible for the full amount. But in some circumstances, the amount of drugs or the purity of narcotics is well above what was reasonably foreseeable to the defendant. And thus, this particular departure, what we can now call the Mendoza departure, could be applicable. So in this case, the Ninth Circuit remands the case back to the district court and instructs the sentencing judge to reconsider the sentencing because, after all, the argument about the amount or purity of narcotics can be considered at sentencing, and that is as a departure beyond what's in the base offense level. Now, in the beginning of this case, of this video, I told you that the federal sentencings have changed dramatically since 1997. In fact, we now know that the guidelines are advisory, not mandatory. So the courts don't necessarily have to go exactly through all the departures in order to give a lower sentence. The courts are now permitted to vary in terms of sentence. Varying is, of course, a legal term that we see in Section 3553. And so I encourage all of you to look at Section 3553 factors, which include the characteristics of the defendant. So the court has to consider beyond the case itself. The court has to consider the defendant as an individual, and then the sentencing disparities between this particular individuals and others that are before the court in imposing the sentence, because at the end of the day, the sentence has to be sufficient but not greater than necessary to serve the goal of sentencing in Section 18 U.S.C. 3553A, regardless of the guideline range. So I hope you've learned something today in terms of departures and variances, and specifically that the court can consider the defendant's knowledge or control over the purity of narcotics. If you like this video, give it a thumbs up. If you're new to the Lost Ash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.